Welcome, everybody. My name is Andy Bonner. I serve as chairman of the Tennessee State Board of Accountancy. Today is July the 25th, Tuesday of 2023. I'd like to call this meeting to order of the Tennessee State Board of Accountancy. This is regularly scheduled meeting is taking place in Bicentennial Capitol Mall Conference Room of the Davy Crockett Tower at 500 James Robertson Parkway in Nashville, Tennessee. The meeting date, time, and location has been properly noticed, and copies of the agenda were posted to the Board of Accountancy website on July the 14th, 2023. I'd ask Karen at this time to perform a roll call and ensure that we have a quorum.
Janet Booker Davis. Here. Larry Elmore.
Here.
David Crenshaw. Rob Vance.
Here.
Kevin Monroe.
Here.
Pam Church. Here. Andy Bonner.
Here.
Greg Gilbert.
Here.
John Reesbeck.
Here.
Brad Floyd.
Here. At this point, we have a quorum. Thank you, Karen. Today we have really one new member that's been appointed by the governor. His name is Brad Floyd. We also have John Griesbeck, who has been reappointed for 3 years and will serve another 3-year term on the board. And we still have open Gay Moon's seat, and we'll know more about that later as appointments are being made right now, or actually interviews. At this point, I want to ask Brad if he would share a little bit about him, and we're glad to have you on the board, Brad, and welcome.
Thank you, Mr. Chairman. It's an honor to be among you. As I mentioned yesterday, I'm a longtime resident of Williamson County, specifically in Franklin. My wife and I have been out there since '82. We have 2 grown daughters and 1 grandchild on the way, so Tennessee's been our home for many, many years. I spent a career in association management, most recently as CEO, 33 years as CEO of a state professional association with approximately 8,000 members. Had the opportunity to interact as an observer and admired the work of the Board of Accountancy for a number of years and somewhat familiar, and very pleased to be a part of it. Thank you.
Thank you, Brad. Brad will be serving as our new public member. So thank you for your service. Another announcement we kind of have today is Dr. Pam Church will be assuming the role of interim dean of the School of Business at Christian Brothers University. Congratulations.
Thank you very much.
We're awful proud of Dr. Church and everything she does for this board and her activity in the accounting profession and training being a teacher of accounting for a long time and on so many committees with NASBA, so much great input, especially during CPE evolution, and appreciate all that you do for the profession. Just want to remind, if we have any visitors or members of the public that would like to speak, that we have a sign-in sheet, and please do so. And then if you want to speak. Also, a period of public comment will be available at the end for that sign-up sheet. So I don't see anybody here today, but somebody may come in. We'll let them know when we get there. With that, everybody's had an opportunity to go through the minutes of the meeting from prior meeting, May 2nd. And do we have to see any changes or any recommendations for change?
Mr. Chairman, would you mind approving the agenda first?
I will. Sorry about that.
Sure.
The agenda is set before you, and it was, again, posted on July the 14th, 2023, and do I have a motion to approve the agenda?
So moved.
A second? Second. All those in favor?
Aye.
Opposed? Okay. With that, then we'll go back to the minutes. Thank you. Keeping me on track there, Wendy. The minutes have been handed out for the May 2nd, 2023 meeting, and ask if anybody has any corrections or changes to the minutes.
Mr. Chairman, there was a noted change under the TSCPA update related to the Center for Audit Quality. There was a spelling error there, so that has been corrected to the final minute.
All right. Do I have a motion to accept the minutes with that change? The second?
Second.
All those in favor?
Aye.
Opposed? All righty. Ms. Carmen? We'll go to the Executive Director's report.
Thank you, Mr. Chairman. Good morning, everybody.
Morning, Cory.
Nice to see everybody. With the Executive Director's report, as normal, we start out with future meeting dates. You'll see the dates that have already been approved, and then I have a proposed date there for October of '24. That would be Tuesday, October 22nd. I'd also like to highlight that our next meeting, October of this year, is actually a Thursday and Friday, which is not typical, but due to meeting location availability, we had to make some adjustments to that particular meeting date. And it's my understanding, Kevin, you will not be available at that meeting, correct?
That's right.
Okay. But please make sure your calendar is correct for that particular date, and we'll vote on the 2024 October date at the end of this meeting, or at the end of the report. NASBA meeting, an upcoming, the annual meeting, the 116th annual meeting is October 29th through November 1st in New York, New York. Our budget does allow for 5 individuals to attend. I believe I have interest from Andy and Greg so far. If anyone else is interested in attending, please email me, and we'll start to get those arrangements approved here in the next month or so. The NASBA Executive Director and Board Staff Legal Counsel Conference is scheduled for March 25th through the 27th, 2024. That's where Duke and I get an opportunity, as well as legal counsel, to gather with our peers across the country. And this year they're doing it in Nashville, so we get to be the host city this next time around. And of course, NASBA is located here in Nashville as well, so I think it's an opportunity for more of their staff to attend the meeting, so it should be fun. NASBA regional meetings, Andy, Greg, Kevin, Pam, and I attended NASBA's Eastern Regional at the end of May in Savannah, Georgia. I understand Janet participated virtually, and Mary attended the Western Regional virtually as well, so we had good participation there. Overall, you know, it continues to be a lot of talk about pipeline initiatives, and specifically we heard LE program, Experience, Learn, and Earn, which is an effort by which NASBA and AICPA are working together to create a program by which individuals can obtain their additional 30 hours by going to work for a participating firm. And that firm would work in conjunction with a university that the program selects to obtain those credits. Any additional credits they need beyond their accounting hours to obtain the 150, they would obtain through that university. So that program is still being finalized, and we do expect in the next week or two an announcement on the specific university and some of the firms that are involved in that. So excited to see how that plays out this fall, and if we see some results there and some interest. And Andy can probably share a little bit more about that if you have later on in the meeting. Our NASBA CPACE contract is up for renewal in March, so that is on top of mind. But they have also asked for an addendum to the current contract. They are trying to pull all of the states together that work with them on CPACE. So I believe it's 32, 33 states where NASBA handles the review of the education and approves the individuals to sit for the exam. So that's what the CPACE terminology refers to, rather than us doing it in-house. They want to bring, all the contracts apparently are all over the place and have different wording and things like that across the country. So they're trying to streamline it. So they've asked for an addendum to help in that process, whereby they do want to update their pricing model, and so that it is the same across the country, and then also to allow for a current contract to continue should the term expire and we're still under negotiation for the future contract. So our plan right now, we've had a couple of meetings with them, is to get that addendum approved by September 1st, and then also be working on the new contract for March. It might seem like we would go ahead and get the new contract, let's go ahead and get it underway for September, but the way the process works for contracting, it's just too quick of a turnaround to be able to do that. So I think we're on the right track with that, and I'll let you know if we have any concerns once we get to the October meeting. Exam fee change implementations was a revision in the exam fee schedule, and that's for the January 2024 rollout of the new exam. The total candidate cost per section will now be $254.80 in 2024, with the various fees from AICPA, NASA, and Prometric detailed in the attached implementation letter that I've included with this report. A core update. So this is the online licensing platform that we have, where you all go renew your license, individuals apply for licensure to change your address, all of the system by which we operate for applications saw a significant public-facing improvement at the end of June. The result of that is that each licensee is going to have to create a new account at core.tn.gov. So it's the same address that you all are used to going to, but you're going to have to create a new account in order to get in, and then your interface is going to look a whole lot better. It's more modern, a little bit easier to navigate. So all the same applications are available. Of course, we have not had a lot of volume. This time of year, we're not in the middle of renewal season. We do have the CPE audit, and then we had some people renewing at the end of June before licenses expired. So we have had some activity, not a lot, but we do plan to do some communications, hopefully next month, and then maybe again in early October before renewal season starts, to try to encourage people to create accounts, get a little bit familiar with the system before our rush of renewals at the end of the year at the beginning of November. So if any of you have not been there and have a chance, please go create an account, and if you have any concerns or problems, please let me know. We can get those handled. Communications on July 12th, our semi-annual newsletter was distributed to licensees via email. We also posted it to the website. So we do not mail that any longer, but it is accessible on the website. Outreach. Since the last meeting, I did attend TSCPA's council meeting at their convention in Memphis and gave a short update on board activities. And then I have had a few calls and meetings with the AICPA Board of Examiners and NASA's CBP admin committee meetings, which we touched on a little bit yesterday with our discussion about the implementation of the move from 18 months to 30 months. That was the main topic of conversation in our CBP admin committee meetings. Board of Examiners meetings are generally an update on things and anything involving the exam. So it is recently noted that volumes are increasing nationwide, and the feeling is that typically happens before you launch a new exam, because individuals want to get in, pass it, and not worry about the unknown. So they did expect volumes to start increasing. Hopefully we can hold on to that. As you might imagine, DEC is seeing the largest increase because that section is going away with the launch of the new exam. So more people are trying to get that one out of the way as they venture into the new exam. So that's really the main information from that meeting. The CPE audit notices were mailed in May. We did, or emailed in May. We then did a mailed letter in June, and the deadline for submission is coming up on August 1st. And I gave you just a quick summary there of the responses as of July 18th. And so we do feel like the response rate is a little lower than we've seen in the past few years. So people just aren't as quick to respond as they have been. So hopefully that's just a pool of candidates and not a sign that people are having deficiencies or unable to get in. So we haven't seen that, at least with folks reaching out to the staff. So far, we have a response rate of 64% and a compliance rate of 98% on what we've received. Performance metrics. These are our internal customer-focused government metrics that we have to adhere to as a staff. So average number of licensing days, our goal is 8. You'll see there, in the past 3 months, we've ranged anywhere from 6.2 days to 8.2 days. Case and complaint performance is a goal of 90% of our cases are resolved within 180 days. We are lower than the goal. This is still reflective of the time period by which we didn't have an investigator. So it just kind of stays with you a while, the way they calculate that number. So I don't have any concerns. We will get ourselves back to close to 100% there. The online adoption rate, that's how many folks are applying for licenses on their initial licenses online. So we have 100% the past few months, so that's great news. Really, the only place that we typically have problems is the firm permit. There's a lot of information required, and sometimes people just feel better sending it in by mail. So, but we encourage them to do that online. And then towards the end of the report here, our new licenses issued. You will see that first quarter, second quarter is listed there. We've issued 240 individual licenses this calendar year and 24 firm permits. We are a bit behind the prior years. I'd say our numbers are closer to 2020 during the pandemic. So keep an eye on that. We have down there at the bottom of that page, I have new candidates sitting for the exam. So I listed there 117 through quarter 1, but on Friday, after I sent this out, I got second quarter numbers. And for second quarter, we had 140 new candidates, and the prior year was 144. So we aren't seeing yet an improvement there, even though it does appear that more people are sitting for the exam. The total volume across the country is up. So hopefully we'll see some improvements in the next couple quarters. And then as typical at the end, I have included our licensee count. We're at 11,934 active licensees. This is after all of the people in expired grades have moved to expired. So this is a pretty good number because nobody's kind of stuck in that renewal process at this point. So we're close to 12,000 active individual licenses, and then we are at 1,769 active firm permits. We continue to see some decreases there overall as far as the number of firm permits compared to last year. And as I mentioned, attached is that fee schedule, and then your exam performance statistics are at the end, and that's for the first quarter of the year. Mr. Chairman, that concludes my report. If there are any questions, happy to talk through them.
Any questions for Wendy? We do have one action item that we have to approve, and that would be to set a meeting for October 22nd, 2024 as on a Tuesday. Do I have a motion for that?
So moved.
Second? Second. All right. All those in favor, say aye.
Aye.
Opposed? All right. Thank you, Wendy.
Mr. Chairman, board member David Crenshaw has joined us on the phone. I'm not sure if David, maybe you can chat Karen and let her know if you'd like to vote on anything moving forward, and we're happy to include you in that. If not, that's fine as well.
I would say welcome, David. We miss you and hope that everything's okay. And just let it, as she said, let Karen know if you want to vote on something as we go through the process. And we'll do a roll call. With that said, let's go to a sunshine law presentation by our own attorney, Neil Stauffer. Welcome. I think that the presentation is also on each one of the small pads that we have in front of us. I don't know if do we have the ability to.
The screen will come down when you're all right, give us just a couple minutes.
We're going to set up the screen so we can show everybody in the room. Bear with us. If you are listening by internet today, you might hear some kind of rumblings and stuff going on within the building. And, the state is improving this building and updating it and really changing some of the technology in it. And so every now and then we get some noise, but we're very thankful for our normal meeting room is being renovated downstairs, and we hope to be back in it in the next quarter and be back to where we have pictures and video of the meeting. But right now, we're very thankful that our state is upgrading the technology and taking us to another level, and we appreciate it.
Thank you, Mr. Chairman. Today we're going to talk about open records and open meetings. This is probably a refresher for a lot of you. So we'll start with this. You were my sunshine, my only sunshine. Everybody knows the song. Good intro for us here. So this is a disclaimer. I'm not gonna read the whole thing, but essentially what this is saying is that don't take this presentation as a substitute for legal advice. If anybody has any questions, that's why I'm here. So feel free to reach out if you have any legal questions. Just don't assume based on this presentation that that's a substitute for legal advice. So first we'll talk about the Open Records Act, or the Public Records Act. And essentially, public records are open for inspection to any citizen of Tennessee except as otherwise provided by law. So it's a very open, transparent standard. And that is under Tennessee Code 107-503. So what is included in open records? What is included in open records for a board or commission? Public records or state records include documents, media, data, other materials, as long as it's made or received pursuant to law or ordinance or in connection with the transaction of official business by any governmental entity. So it's a very broad standard. What would not be a public record would be, say, your iPads that you have materials on. The device itself is not going to be a public record, but the data itself, the documents themselves would be. Okay, so that's essentially the Public Records Act. Moving on to the Open Meetings Act. This is under Tennessee Code 844-101. And this is kind of our roadmap. And first, we'll talk about what is the Public Meetings Act, or the Open Meetings Act. Sometimes you'll hear it called Public Meetings Act, Open Meetings Act. You'll also hear it called that. So the terms are kind of interchangeable. So what is the Open Meetings Act? What is a meeting, and what is not a meeting? And what is required for a meeting to be covered by the Open Meetings Act? You got to have notice. We do that through our agenda. And if the board violates the Open Meetings Act, what happens? And essentially, the proceedings are nullity at that point. So we'll talk about all that. So Open Meetings Act definition: the General Assembly hereby declares it to be the policy of this state that the formation of public policy decisions is public business, will not be conducted in secret. So a very strong preference there toward openness and transparency. Can't deliberate in a private meeting. Tennessee Code 844-101B. This part shall not be construed to limit any of the rights and privileges contained in Article 1, Section 19 of the Constitution. That's the section of the Tennessee Constitution that deals with free speech. This is just saying that nothing in this act is can be interpreted to interfere with people's free speech rights. The Open Meetings Act is remedial in nature, and there's a case for some bedtime reading for you if you want to look it up and take a look. But basically, the gist of this is that there are deliberations going on.
Yeah, can I ask a question?
Yeah. Yes, sir.
Deliberate.
Deliberate would be if you're suggesting an opinion on something, then that would cross the line into deliberations. And we'll get into that a little bit later as far as, is it okay for a board member to email the chair or email another board member and say, hey, I've got an item for the agenda. This is a newspaper article that I think would be good for us to discuss on the agenda. Yes, that would be fine. But if you're emailing or talking to another board member and saying, this is something that we should consider for revocation, we should do this concerning an applicant, this is the type of decision that we should make on something, then that's crossing the line into deliberation. If you're suggesting a course of action on something.
Okay, let me give you an example of my question. Say we take a break at 10 o'clock. We've already voted on something. It's history, it's done. And during the break, we say, gosh, that was a long discussion. Can't believe how complicated that was. The decision's already been made. Is that deliberation?
If you're just making a comment about how complicated it was, I don't think that in and of itself would be, because you're not deliberating on the substance of the issue at that point. And as you said, the decision's already been made. Probably just to be safe, in an ideal world, I would advise avoiding any discussions whatsoever about, things that happen in the public body. But in that particular hypothetical, no, just saying that, hey, that was complicated, or man, that meeting lasted a long time. That's likely not going to be considered deliberation. And especially in light of what you said, that the decision's already taken place at that point. But, you wouldn't want to get on the phone or send an email talking about something that either is on a board agenda or could be on the board's agenda and express an opinion one way or the other.
It has to be two board members, right? In other words, I can call Wendy and talk to her about it.
Correct. Yes, sir. That's right. And you can call me as well for legal questions. But that's right. It would have to be in violation of the Open Meetings Act. It would have to be two board members, two or more deliberating on something in private, and that's a huge red flag. Okay, next slide. Open Meetings Act application, all meetings of any governing body, and this is a governing body, are declared to be public meetings, open to the public at all times, except as provided by the Constitution, what we've already talked about. And some of these slides are somewhat duplicative, but they are just kind of hammering home some of the important points here to make sure that we get it. So what is the governing body? The members of any public body which consists of two or more members with the authority to make decisions for or recommendations to a public body, decisions for or recommendations to a public body on policy or administration, and the Open Meetings Act applies to all boards and commissions. Open Meetings Act applies to every meeting of a board or commission. So if there are two or more members who are coming together to deliberate on something, then the Open Meetings Act is going to apply. A meeting means the convening of a governing body of a public body for which a quorum is required in order to make a decision or deliberate toward a decision on any matter, and that applies to board meetings, it applies to committee meetings, it applies to subcommittee meetings as well. So what is not a meeting? A meeting does not include any on-site inspection of any project or program. That's likely not going to be applicable to us because, to my knowledge, we don't have inspectors. So but for other boards, it would be applicable to them. What is not a meeting? What else is not a meeting? A meeting does not include a chance meeting of two or more members of a public body. However, you can't use that as an opportunity to discuss public business or deliberate on public business. So if one board member sees another board member at a restaurant or at the grocery store, you exchange pleasantries. Nothing wrong with that. You shouldn't talk about board business. What else is not a meeting? So this is the Tennessee Attorney General opinion that deals specifically with sharing a meal. So you can share a meal with one another. You can go to lunch. You just can't talk about board business. If it's not a public meeting. What is not a meeting? Lunch breaks, restroom breaks, smoke breaks, recesses. All of these will be times that board business should not be. So TCA 844-103 A and B, regular meetings and special meetings count as meetings and are all subject to the Open Meetings Act. So it goes for regular meetings and special meetings. Exception would be executive session. So executive session would be if there's a lawsuit and the board is meeting with me and or the executive director. Then that does not have to be publicly, that does not have to be open to the public. Executive sessions occur when one or more members meet with the board's attorney and the board is under lawsuit or has been threatened with suit, and the members ask their attorney questions related to such suit. And again, that type of meeting would not be open to the public. And if there were an executive session that needed to be called, you would be aware that this is an executive session and not a public meeting. Hopefully that doesn't happen with a lawsuit, but you never know. The board may not deliberate about any specific matter before it or potentially before it in any executive session. And those are some cases that stand for that proposition. So how far does this go? So there's an Attorney General opinion that talks about how specifically in this situation, oral interviews conducted by the Civil Service Commission in Maury County with persons applying for jobs within the service of the Sheriff's Department did actually come within the Open Meetings Act. So, it can be pretty expansive in terms of if it's a meeting of a governing body, even for this purpose, then it was deemed to fall under the Open Meetings Act. So that's just another example of the preference for transparency that we have in our laws under the Open Meetings Act. Okay, so this is kind of what I was touching on earlier as far as deliberations. If a member were to email the chair and say, here's a news article, I'd like something included on the next agenda pertaining to this news article, or I'd like this news article put on the next agenda. That's not public business. But if you go a step further and say, here's a news item about one of our licensees, we should consider revocation, then that's crossing the line of media operations, and that's what I would recommend you stay away from. This kind of touches on requesting legal advice up front. If you have a question, I would just recommend emailing me if it's a legal question up front and just saying, I've got a question about legal concerning something the board has done. What you wouldn't want to do or what we would recommend you not do is say, I've taken this action as a board member and somebody's upset. Just recommend that you request advice on the front end. This slide basically is saying, if you need to call another board member concerning something that's not related to board business, then I don't know, kind of in your lives outside the board, whether that needs to take place at all, but as long as it doesn't concern board business, and you're not talking about board business,
I have a
then it
question.
should be done.
I have, Kevin and Wendy coming to a, Tennessee Society of CPAs conference in October to speak about, evolution and things that we've discussed at the board. I will be there, obviously, and he will be there. Is that in violation? I mean, I think they'll have prepared remarks about things that we've discussed at the board meeting, but nothing upcoming. I just want to make sure that we're not going to get in trouble doing something like that.
Is it discussing things that have already been deliberated on by
Yes,
the board?
yes, yes.
Then
That we've already discussed in the open and public, voted upon. There's nothing new. I don't think there'd be anything new. It's just to inform our members what's going on, in the profession.
Yeah.
New things.
I think you're fine there in that example. That's not, going to be looked at as deliberation. If it's already been deliberated on and discussed in an open meeting to the public, and decided on, it's just presenting the information at that point. You're not deliberating on anything. That's really a key.
And I wouldn't probably have any interaction with them per se, maybe just to introduce them. So,
Neil, if I can add, also, we've done things like that before, and all of the materials are reviewed by the legal team before we do any of those types of presentations. So if it's Kevin and I doing something, then they will look at it before, so they know what kind of information we're sharing.
okay. Well, you'll get questions, I'm sure, if it's not on the agenda.
Yeah.
So, I mean, I guess they would just have to be cognizant not to discuss anything that's new or pending or anything like that, right? I mean.
Yeah.
And also, we tend to do it in our personal capacity and make sure we reiterate that we are not presenting something as though it's an opinion of the board.
Okay, good. Okay.
A couple of years ago, there was a disclaimer.
Yeah.
That factor example one, Larry, I think that was something that you had developed or had used, or a disclaimer saying that.
Legal has provided us with one that we can use, yes.
Okay, so you've done this before, and okay.
Yeah. It's a pretty common thing with multiple different boards and commissions.
Okay, thank you.
Those are the safeguards we put in place to kind of help with that.
If one or more members cannot attend a meeting in public, the absent member can participate telephonically, but all votes, if the telephonic member is participating, must be roll call votes. That's so the public can know how each board member is voting. If a member cannot attend a meeting in person, you have to have a quorum based on those who are present. So that's TCA 844-108. So if those members present in person make a quorum, then the meeting may proceed. A physical in-person quorum is still required, even with telephonic participants. This is just a slide touching on that the Act, the Open Meetings Act, is to be construed most favorably to the public and is all-encompassing and applies every meeting of a governing body, unless it is specifically excluded. So that's, again, just reiterating what we've already talked about. The strong preference for openness in our laws. Okay, the public has the right to attend and observe your meetings. They don't have the right to participate if they're being disruptive. That would be a law enforcement issue if that were to happen. But there is now, and what we have now is Public Chapter 300, which is codified in state law and amended the Open Meetings Act 8-44-101 and provides for a period of public comment. So that's why we have the period for public comment now on the agenda. And the wording of this is that comments shall be allowed at each public meeting concerning items on the agenda, except for disciplinary hearings. So we would not want the public discussing, it would not be appropriate to discuss matters on the disciplinary report or the legal report. But it would, any comments that are made would need to be germane to matters on the agenda. There's a three-pronged test for adequate public notice. The contents of the notice have to reasonably describe the purpose of the meeting. So that would be on our agenda. That's how we accomplish notice. And that's posted on the web. And the notice has to be posted at a time sufficiently in advance of the meeting. So under state law, that has to be posted at least 48 hours in advance of the meeting. Ours are usually posted well in advance of that. And then notice has to be posted in a location where people could easily become aware of the notice. So the method that we use is the internet. So it's posted on the department website and the board website. This is an AG opinion that deals with what constitutes adequate public notice, and that's contingent on the facts and circumstances, kind of a totality of the circumstances approach. Whether the location would be one where members of the community could become aware of the notice. And with our practice of publishing it on the board's website, that's going to meet that standard. Okay, so what is the effect of going through a meeting or the board taking action on something, and what if the Open Meetings Act is violated? What happens in that case? Then the proceedings are a nullity if that happens. So, for instance, if you have a rulemaking hearing, let's say notice was not given properly, let's say it's questioned at some point, what would happen in that case? The rulemaking hearing would be deemed a nullity, and then you have to start all over. So it's important that we make sure that we're abiding by the Open Meetings Act. So in a nutshell, kind of a summary here, summary slide. The Open Meetings Act is designed to make sure that board business is accessible to the public. It applies to you, its members, and collectively the board. All gatherings of the board are meetings and are covered by the Open Meetings Act, except for executive sessions, which we talked about. And you have to give public notice of the board meetings, which we did through our agenda. If you violate the law, any violative acts are void or a nullity, and there can be costly litigation that are assessed against the board. Okay, this is the NC Board of Clinical Examiners versus FTC case. So this is a 2015 case, U.S. Supreme Court case. And this deals with anti-competitive conduct. So it basically, it's talking about unreasonable restraint of trade. It basically is standing for the proposition that you cannot restrict people's ability to work. So what happened here was the North Carolina State Board of Clinical Examiners, they issued unilaterally, without state supervision, 47 cease and desist orders to non-dentists. So what was happening in North Carolina was there were a bunch of these kiosks and non-dentist entrepreneurs who were putting up kiosks in malls and starting small businesses to do teeth whitening. And these were non-dentists. The dentists didn't take too kindly to this because the non-dentists were charging quite a bit cheaper for the teeth whitening than for the same service than what the dentists were charging. So the dentists who made up the dental board unilaterally, without state supervision, sent these cease and desist orders to the non-dentists to get rid of the competition. The FTC filed a complaint alleging the board violated antitrust laws, and the board claimed state action immunity. Under state action immunity, that was a doctrine created by SCOTUS, Supreme Court of the United States, in 1943 in a case called Parker v. Brown, to protect states from antitrust claims when they exercise authority to impose regulations with anti-competitive effects. So the board was trying to claim immunity under that doctrine, state action immunity doctrine. The FTC ultimately prevailed at SCOTUS. And the court rejected the state action immunity defense because the board did not receive, in this case, active state supervision. When it interpreted unilaterally the Dental Act, the NC Dental Practice Act, as addressing teeth whitening, and when it enforced that policy of issuing the cease and desist letter. So the question is, according to the court, whether there is more than a mere facade of state involvement, and there has to be more than a facade of state involvement in terms of supervising the board. Because there is a need to ensure that states accept political accountability for anti-competitive conduct that they permit and control. So you can't just say, well, we're supervised, but not really have any procedures in place for the board to be supervised by the state. So the court found that rec boards have to have active state supervision. So what is active state supervision? So the question is whether the state's review mechanisms provide realistic assurance that a non-sovereign actor's anti-competitive conduct, what this board would be a non-sovereign actor, promotes state policy rather than merely the party's individual interests. So is the anti-competitive conduct in furtherance of state policy, or is it in furtherance of our individual interests, like wiping out the non-dentist teeth whitening competition? That's the question that the court honed in on. So, as a result of that case, saying that there has to be active state supervision, in 2021, Tennessee enacted TCA 4-4, Clause 65, which establishes supervising officials, which that's the commissioner or the commissioner's designee. The role of the supervising official is that they ensure that the actions of the boards that displace competition, if any, are consistent with a clearly articulated state policy. So under TCA 4-4-125, with respect to any action other than rulemaking that the board takes, the supervising official shall evaluate whether the action may constitute a potentially unreasonable restraint of trade that requires further review. And if it is determined that action requires further review, the supervising official has to do all these things: provide notice to the board within 10 days, review the full evidentiary record, conduct a review of the substance of the action de novo and on merit, and then in writing either approve, remand, or veto the action. That's all if the supervising official has to get involved because there is some action the board has taken other than rulemaking that could potentially involve unreasonable restraint of trade. The takeaway from this is that if there is anything the board ever does that even approaches unreasonable restraint of trade or anti-competitive conduct, red flags are going to be off. I've got my ears attuned to that, and my supervisors have their ears attuned to that as well. So, the board would be aware of that, and we would deal with that at that time. But not in furtherance of state policy. And the question of whether it's in furtherance of state policy that really falls to the supervising official who is actively supervising. We do have active supervision in that way, in that regard, who are looking for those types of red flags that may pop up in terms of the board doing something that may be looked at as anti-competitive. Any questions about that?
That means, Oliver's been on the board for a long time. When that case came out in
2015.
there was a lot of concern about liability of the board and so forth because of that case. Are you saying that this active supervision kind of protects us from that?
Well, yeah, it is a protection. I'm not, and there is it possible that that board members could face some liability? I think that it's possible, but this is another protection that's there to ensure that, before we get to the point of any anti-competitive conduct that may be looked at as not furthering state policy, that we've got a supervising official there to step in and go through this process and make the decision, essentially, kind of have veto power over what the board, any action that the board is taking that could be interpreted as anti-competitive. And yeah, I would say that it acts as an additional layer of protection for the board.
Any other questions for Neil? Neil, thank you very much for bringing that and updating us with it.
Yes, sir.
I know that is something that every board, I guess, in Tennessee wants to make sure that they understand and know. I do not recall getting a copy of the presentation. Can we get one emailed out so we can have one ourselves?
Sure.
If we ever want to look back and take a look at any of the code sections or anything, it might be helpful.
Oh, I apologize. That particular presentation isn't available.
Okay.
Yeah. Okay.
Okay.
Okay, I'll look into it further.
All right. All right, we'll continue on, and reinstatement application has been received. This is an application as a step one in a two-step process, and that was received here, and I'll turn it over to Wendy and let her go through that application, and this will be an action item. Normally, when the application is made, we don't have the individual come and talk to the board. It's more or less a presentation of whether they qualify or not, and then at that point, we ask the individual to come back to the board for the second part, and sometimes the board actually asks that individual to be present for questioning on the reapplication, so, for reinstatement.
Thank you, Mr. Chairman. As Chairman Bonner stated, as we go through this, please think about whether you would like this person present at the next meeting, because we'll want that to be part of the request when you all vote on this. So, as he mentioned, this is in accordance with our rules. When someone's license is suspended or revoked, they can request reinstatement of that license through our rules, our reinstatement rules, which is in Rule 20-01-.10, reinstatement of revoked or suspended licenses. In this particular case, we have Scott Dahlberg, who is requesting reinstatement of his revoked license. Mr. Dahlberg faced disciplinary action in 2018. I will summarize kind of the reasons behind that action in 2018. Mr. Dahlberg held license number 21546. He was employed by a local car dealership from October 2013 through July of 2016, when he was terminated from that employment. During that time, the respondent encountered several unforeseen pressures, all of which were unlikely to recur, including a premature birth of twins, serious health problems with family members, and some pre-existing debt that has now been satisfied. That was as of the consent order. In response to those particular pressures he was having in his life, respondent withdrew $50,000, a little over $50,000 in funds from his employer without authorization to pay for his family's needs in an effort to ensure their health and safety. Around 2016, July 29th of 16, respondent took sole responsibility for those actions with his employer, and at that time was terminated. Respondent then paid full restitution to his employer, and as a result of this consent order, the respondent agreed to those facts. As a result, the order was for the respondent's license to be suspended for a period of 3 years from the date of this order. The respondent's license was expired at the time, so the board did require them to reactivate that license, and then it was suspended. During the term of a suspension, anytime someone's license is suspended, they're required to complete continuing education and renew just like you normally would. They just don't have the privilege of using the designation during that time. And so that order was signed January 9th of 2018. And then after the license was suspended, it came to the attention of staff that he did not comply with the suspension of the license by renewing and completing continuing education. So the license was ultimately revoked for failure to comply with the consent order. So we have a revoked license that we're talking about today. Mr. Dahlberg has submitted this reinstatement application. When somebody submits the application, they have to complete the application, they have to pay a $250 reinstatement fee, and we gather the information that we have on file and present it to you as a complete application for your review. And then at the next meeting is when you will consider the application and the information provided in order to make a decision on whether you'd like to reinstate that license. So one of the other requirements of the application is to submit a petition explaining your reasons for wanting your license back, what's gone on, your remediation efforts during the time that your license was suspended or revoked. So you will notice as part of this packet, you do have a petition from the respondent prepared by his counsel. So it is fairly lengthy. It's a 4 to 5 page document here. Would you like me to give you all a chance to look at it? Do you feel like you have had a chance to review that petition? Again, we're not going to be talking today about the merits of the reinstatement. We will just be looking at whether you feel like you have enough information and the application is complete for us then to actually consider reinstatement at the next meeting. And as I mentioned before, I'd like you to consider whether you'd like to invite him to be here to ask questions, to answer questions as part of that. Does legal have anything to add before?
I think that covers it.
Would y'all like a chance to read through that, or we can open it up for any comments?
Did he catch up the CPE hours through 2022?
So we have not verified that. I think in the petition he talks about that he did, or that he worked on some, but we have not gone to an effort to check that. So in the rule, there's no CPE requirement, so that would have to be a request of the board for us to check or look at current CPE. And typically that's done at the reinstatement process. If you choose to reinstate the license, you can then ask for CPE as part of that reinstatement.
No, I mean, he was required to fulfill CPE
Right.
requirements, and he fell behind on that.
Correct.
And then it says here, on number 11 of his petition, that he obtained 112.5 hours in 2021 and 22. Does that catch him up through 22?
That is the statement made, and that,
If it's true.
we haven't verified it.
Okay, if verified, would that catch him up?
Yes,
Okay. And he's working on 2023 now.
that's what he states in the petition.
Okay. Right.
Assuming we go to step two, I think it's always helpful for the applicant to be here. I think it's good to, look them in the eye, ask them questions, and I think it helps determine sometimes why they did it and whether they're sorry for doing it and all that kind of stuff. So I would recommend that we, assuming we approve this application to go to step two, I would recommend that we invite him to be here.
I agree, that's consistent with what I recall we have done in similar situations.
I would almost say, ask the staff to check his CPE
Okay.
as he's coming in to see if statements he's made true about the CPE are actually true.
Are you legal? Is that something we can gather in between?
Yeah, you can
Okay.
gather it in between. If that's the goal of the board, to have them come in, at the second meeting, then, yeah, they'll get back to, you can gather that information. Yeah, there's nothing preventing you from doing that.
Okay. Just make clear what years you would like us to check, and we can certainly do that.
Any years are closed, so 21 and 22.
Okay.
So I had a question that's related to that, and so it's, I realize that we're not considering the merits of his reinstatement now, but we're considering the adequacy of his application and whether it addresses what it needs to address. But we have at least two things going on here. So number one is, despite the consent order that he signed, he did not comply at times with his CPE requirements. And he also did not, through what is listed as a misunderstanding, deal with his renewal fees in an appropriate and timely manner. And so my question is, does that constitute a flaw in his reapplication that we should consider now at stage one here? Or is that more of a substantive issue that would be considered in stage two if we get to a second meeting here?
Would recommend probably best to consider it stage two, because at this point, it's under the rule, it's such application shall be submitted to the board at its next meeting, which is this meeting, and evaluated, meaning discussed, and reviewed for presentation at the following meeting. So at the presentation stage, I think would be the most, that's where you're gonna really decide on the merits of it. Does that answer your question?
Somewhat. I guess the question really I'm getting at is, does the executive director and does legal counsel believe that the application that has been submitted for reinstatement meets the criteria so that you could recommend proceeding to the second of the two-part meeting structure that we have?
I think the petition is complete from the staff perspective.
Yeah,
There's nothing missing.
yeah, everything, that is required by the rule seems to be there.
Okay.
With regard to the CPE, it doesn't, is that the part you're getting at, the CPE part?
And the renewal fees,
Other renewal,
misunderstanding, at least as alleged by their.
So that was really, I feel like, correct me if I'm wrong, but the failure to get CPE and renew the license resulted in revocation. So that part has been dealt with. And now we're at a point where he is requesting reinstatement of the revoked license, and according to the rules, has met the requirements for the application.
thank you, that does get at one of my questions.
Okay.
So Wendy, would that imply that it's not appropriate at this point to go back and see if he received bills for those fees? Because basically, he's already been given the repercussions for not paying the fees, and now we're considering whether to reinstate him after that action. Because that was the question I had. He says he doesn't recall receiving bills or other notices, but maybe that's not part of it.
I think we discussed this and we felt like it wasn't part of it because the revocation was what the result of that. That was the consequence for that.
It culminated in the revocation, and that kind of took care, that was the resolution.
So he wouldn't have to, I guess, be in compliance with paying the fees, getting the CPE?
Because he wasn't in compliance, his license was revoked.
Right, but, I mean, that's kind of, okay, well, here's your fine, pay it. And, I don't know, it just seems like it would still, they still need to pay the fees and complete the CPE.
I think is that something that they could request if they chose to reinstate the license? Meaning the board could choose that at that time?
So, under the rule, the board may impose appropriate terms and conditions. Appropriate terms and conditions for reinstatement of a license or modification of a revocation, suspension, or probation. So, I think if you wanted to order additional CPE credits in order to be reinstated, I think that could be viewed as a reasonable condition for reinstatement. I don't know that going back and assessing essentially what would amount to, overdue fees from the time that he was under discipline before, that ultimately, due to all that, ultimately resulted in revocation. Kind of, that instance was summed up in revocation as the disposition. I wouldn't recommend going back and kind of reassessing those or re-adjudicating that, since it ultimately culminated in the revocation. But I do think that, an appropriate term and condition for reinstatement would be the board saying you've got to come up with a certain number of hours of CPEs in order to be reinstated. But I think I would advise staying away from. Has the board ever done that before? Assessed overdue fees in the past on these?
Not that I recall.
Okay. Fees that were renewal fees that were not paid at the time. Board has not done that.
Not that I recall, but I also don't recall a similar case
So how would that differ from many times we make people catch their CPE up before we reinstate?
I think that's fair. I think this
What's the difference?
Well, he's talking more of paying those back fees.
Paying the back fees that ultimately resulted in a revocation.
Yeah, but
Kind of
what's different from that and making them get their CPE caught up?
I think in terms of a reasonableness perspective, that there's a distinction there in terms of, are we piling on additional fees on top of something that was already disposed with a revocation, and already culminated in a revocation, versus saying you've got to get, due to what we know about your history, you've got to get additional education hours before we're going to reinstate.
I don't think we give them CPE. I think we give CPE, prepare them to enter the jury.
Right.
Fees, the fact that they weren't paid, that was essentially punished, you could say, with revocation. But, so paying them at this point, we're not giving the license back for that. Anyway, I think maybe moving forward, I can understand.
And that he's already paid the application fee, is that correct?
the reinstatement fee.
Does that come close to what
The reinstatement fee is a $250 fee, and the every 2-year renewal is $110. So it's not far off. I think when the board has assessed, I think Pam might have led with this, but when the board has assessed CPE, it's mainly to, like you said, get up to speed to make sure the public is protected once you enter back to the profession, not as a verification of what you should or shouldn't have done prior.
If I don't renew, and I don't complete my CPE, my license will be revoked.
It would expire.
Okay. Is there any distinction here that those requirements were a part of the order? If he agreed to, or is it still just go through the normal channels of he was suspended, then didn't comply? Is there any different filter here, or different application? It seems like the order clearly says, he can be suspended,
Yeah,
get
I see
these
what you're
other
saying.
things.
Yeah. So the fact of not completing the CPE and not paying the renewal fees was actually part of the order that he
Right.
failed to comply with.
That somehow distinguishes.
I think that's where we had talked and felt like the revocation was the punishment for that. But
Yeah, I don't think that changes my analysis on it, but ultimately it's still,
basically what we've done in the past, Neil, is we try to make sure they've complied with the consent order. And I think that's where we're wrestling with.
Right,
That
he didn't comply.
He didn't
So
comply
now
with the
he's got
consent
waived
order.
his right.
But the way we had previously talked about it was we felt like, although he didn't comply, he was revoked as a result of not complying, and now we're here. But
But still would be making him comply.
Right.
If he doesn't have a payment fee.
right,
A question on this CPE thing, analyzing the years that he's given us the CPE, 2017, he got none in 18, none in 19, then he got it in 20, 21, 22, and he's an even number license, so he would have renewed, I guess if we don't count 2017 in his total, or if you do count 2017 in that 6-year period, he got like 41 hours per year. Okay, if you don't count 2017, then he's still out of compliance. You know what I'm saying?
Mm-hmm.
So he got suspended, or consent order was in August of 2017.
18.
Well, it's signed in 17.
Consent order?
That's when he signed.
Well, that's when he signed it. The date,
Okay.
the official date is the date we signed it.
You signed it on January 9th of 2018.
Yeah.
So when would he?
We renew in 18.
Yeah, he would have renewed in 18.
And he did not.
Okay. So does his cycle restart in 2019?
Yeah, 1920. So he would have had a 1920 renewal period and then a 21-22.
Okay. So I don't think he's still in compliance then with the CPE. If you eliminate 2017's 79 hours, and that's on page 2 of his petition. Yeah, that puts the average not enough. So.
and that's where the board could say he's got to, complete a certain number of hours before reinstatement.
So I think what they're asking, in a way, Neil, is do they have the authority to go back and say you have to comply with the consent order by providing CPE for those years?
Yeah, 'cause if we eliminate 2017 in his total, he's only gotten about 34 hours per year for 2018 through 22. So he's not in compliance.
Yeah, I do believe that, to answer your question, I think that would be within the board's discretion to say you've got.
I think what you're gonna find,
Catch up with the CPE.
what you're gonna find is he's not in compliance, because he pretty much says he's not in compliance.
Right.
So, we can gather and verify what he did have during those periods, and then you all can consider that at the next meeting? Would that be fair? to say we can collect certificates for whatever periods you all designate, and that can be reported in the presentation at the next meeting? Or, are you feeling the application is not complete because we don't have that information?
Well, we don't know what his 2023 is. He's saying he's doing,
Yeah.
completing CPE in 2023. We don't know how many hours. It's gonna need to be a lot more than 40, to catch up. Seemingly, maybe 60 or so that he needs to catch up. Depends on what he's been doing in 2023. So I'm just saying, if he comes here and we start looking at the numbers, and he's not gonna fly. So, is that something you can do now, is to look at, get his certificates, compile all this together, figure out what years we actually need to apply those CPE hours to, what renewal periods, to see if he's, if 2017 counts or not. You know what I'm saying? Just run the numbers on what renewal periods needs to have occurred, would have occurred, to put him in compliance. I realize he didn't do the fee. I guess that's another issue. We decided that we're not gonna deal with the fee, but it's the hours would seem to be short, depending on how you run the numbers. So, just talk amongst yourselves on that one, I guess, with him.
And the board could decide today, you could say, well, we're gonna, require him when he comes in at the next meeting to bring, or before the next meeting, to submit certificates.
Yeah, I would like for y'all to do that
Yeah.
before we get to the meeting. So, that's just my opinion. I mean, does that make sense?
Yeah, I'm troubled by his non-CPE compliance, and I'm wrestling with, in this context, since he violated the consent order by not being in compliance. I mean, to me, it's more than the ordinary run-of-the-mill non-compliance with CPE case. But how do you remedy that?
Yeah.
Well, if someone was deficient, we have a formula that says, here are the hours that you would need to submit in order to get back into a good state. And I think they ought to apply to this individual, and I think it would behoove him and us to kind of know that, at least know his status on that before he walks into the October meeting or whatever meeting it will end up being. And it would behoove him to try to get into compliance between now and October, because that's gonna be pretty crucial in my estimation, in terms of whether we should honor a request to reinstate.
He makes the statement he's willing to earn further CPE hours as a condition precedent to reinstatement. So, I mean, it's on the table there.
Yeah.
I have a clarifying question, I guess, for Rob. I mean, his compliance period would have been, his renewal period would have been 17 and 18 based on an even.
Yeah.
So he had 79 hours and 17. I mean, if they're legitimate, correct, I'm not sure why you throw those out. It seems like you would have been one short potentially, right? For
You said
17,
20 minimum each year,
Yeah.
so he would.
Well, okay, he would have been
He would have missed that and then had 10 weeks of that.
for 18, really.
Yes,
And then he would have gone 19 and 20. So he has none in 19, he has 56. So he's got a penalty for nothing in 20, then he's 24 short of 80, I guess. Everything else being correct. So he's probably got two periods there where he's short.
Right.
And to Kevin's point, you could have applied penalties, additional hours, and then the 21, 22, if these are correct, he's probably okay. And with some carryover to 23. I guess just that's the way it would have worked.
Well, I was just saying, if you cut him off at his 2018 renewal period, okay, and those 79 hours are gone to that period, then we restart fresh in 2019.
That's right.
19, 20, 21, 22, okay, which, so it's 160 hours that he needed during those two renewal periods that he didn't get. Didn't get 160. That's what I'm saying. He's short during the 18, 19, the 19, 20, and the 21, 22 period.
Well, I see a lot of questions in that area, and I think that there's a lot of logic there that would probably, the board may want to consider a motion that may deal with the staff actually verifying those hours. Not only getting a total on the list, but verifying that they were completed and they have proper documentation.
I'll be glad to make that motion. That's okay. Now, I move that the staff confirms the CPE certificates through 2023, applies them to whatever period they were supposed to apply to see if he is in compliance. I guess during a renewal period, and or into totality, in terms of all of the hours that he needs. And does 2017, have those expired back to the 2018 period that he was not in compliance? I know that's a long motion. All right, let me restate that.
Before you do, Rob,
Yeah.
I just make a suggestion. So the consent order was signed in 2018. Maybe for the sake of ease for everybody, we just look from 2018 forward, from the CPE, to tackle the CPE issue.
Yeah, but in totality though, okay, because 18 would have he would have cut off at 18. That's what I'm saying, and so he would not have been in compliance for the 17-18 period.
Well, it
That's
doesn't
part
look
of the
like it,
order.
but we don't know. I mean,
Okay.
Yeah.
All right, let me just, I guess, rephrase the motion that the staff verify his CPE and determine what periods that they need to fall into, see if he's in compliance through 2023.
Okay, in that order, do we need to go ahead and say that if he is in compliance, then allow the reinstatement to come forward, or just to be presented at the next meeting again before we allow that?
To further the motion, and if he is in compliance, to allow it to be brought forward to the next board meeting in October. Is that the proper wording?
So he's not gonna be in compliance.
So really, we just try to verify
Right,
his status
right. I think,
versus the order.
I think it might be better to have us pick your period that you would like us to collect CPE from, and we will verify it all and give you information when you discuss with him at the next meeting, and that may make a difference on whether you determine he was in compliance or not, or how much you want to assess if you just choose to reinstate the license.
Well, in the motion, I think it should be any CPE that he has said that he has taken on the reinstatement, that pertains from 17 forward. He's made a statement, and it's an ethical statement, that he has accomplished his CPE, and, you know, I just want to make sure that we understand that that was accomplished.
Right.
As part of the reinstatement, because that's key for the reinstatement, I think.
Do we have the ability, though, to compile it all together in totality? Because we're talking about 3 renewal periods.
I was gonna leave that up to staff. We're just
No.
verifying if you got the CPE.
We can do that. I think the only potential hiccup is that I can't quickly get to it. Maybe Karen or Neil can help me, but I think there may be a requirement that you're only required to keep your records for 5 years. So we may run into trouble with 17-18, on his documentation of CPE for that time period. We can certainly request it, and then I can report on what he had available, and you all can make decisions based on that.
Well, and his petition says, and it lists the years,
Yeah.
is evidenced by certificates of completion in his possession.
Okay.
So at least at the time he made the petition, he presumably had the records. Maybe one way of tackling this is to indicate that he should forward the certificates of completion for all CPE that he has represented in his petition that he has completed. So that would list the years that he's listed. It would also include the 112.5 quote-unquote additional hours that he says he completed, and whatever he's done to date in 2023. Would that be a way of?
Well, the 112.5 is C and D right there.
That's what I was interpreting
Right.
it as. It's a little ambiguous, but that's what I thought he meant.
Right. That's what, it totals up to that. All right, I'll withdraw that motion then, and then,
You could require him to submit what he has, and then that could be, you know, brought to the next meeting, and then you could assess it at that time on whether you deem at that point that he has come into compliance to your satisfaction, and if not, you could then assess or require additional CPEs.
Or not accept, or not approve a reinstatement.
Or not have a reinstatement, right?
Yeah, I think
That was my question, that was what I was not following. It sounded like people were saying if he does not meet those CPE requirements, if he has not already, then you just don't go forward. But in fact, what you just said, it just adds to the case that we consider.
Exactly. It's not a bright line rule as to whether, back to 2017, did he meet, did he have a certain number of CPEs that's going to be dispositive for you in making this.
But we can certainly take that into consideration and use it in making decisions.
That's exactly right.
And I think it would help in staff determining what would be the deficiency under our existing rules. And what would we normally imply as penalty hours?
Yeah.
So we could have that, and that would be helpful information to have if we decide to reinstate conditionally upon his completion of those, whatever those hours would be.
I agree.
I'll make a motion that we approve his application for submission to go to step 2. And as a part of that approval, we ask him to submit CPE certificates that he refers to in his application prior to the meeting,
And request that he be.
and that he be present.
So we would approve his application without it being.
So we're approving that his application is complete, that he has fulfilled the completing of the application.
In filling out the paper.
Yeah.
Yeah.
Because you got to take step 1, and then it goes to step 2, step 2 is where we approve him to be reinstated or not.
But there's kind of a step in between. We're verifying that his information in his application is correct by his own statements.
I thought we were going to ask him to send that before the meeting so that we could discuss it at the meeting.
You can do that as part of the initial step. That can be part of the motion, because this initial step is for review and evaluation. And then I think, Mr. Elmore, if I understand your motion, it's to move it to the presentation stage, which is the second stage. And along with that, require those certain things of the applicant.
Yes.
Is that correct?
Yes.
Okay. Which is permissible for you to do.
But otherwise,
Because you're not approving reinstatement right now. You're just motioning that we move it to the next
I
step.
think we can.
No, we can't, under the rules.
I would second the motion.
Otherwise, we're going to move this whole thing for another next meeting.
So the motion is to move this to move that it go to the presentation stage,
Yes.
which is step 2.
Yes.
And then along with that, require the applicant to be present at the second stage and present the certificates.
And that he sent his certificates prior to that time.
Right, verification.
For staff to evaluate.
Yeah. Right. I mean, we're still going to have another shot at it in step 2.
And certificates going back to 2017.
We're just verifying what he's got in his.
In his petition.
Right.
And then we have the ability to determine if there's anything else, that if he's under that required amount, what we can say that he has to complete before.
Yes, at the
I'm just
second,
trying to
at
move
step
it
2,
forward.
yes.
Just trying to move it forward to the next step, as opposed to delaying the whole process. We still have another shot at it.
I will say that he needs, according to him, he's got 241 or 242 hours, and each 240 during that time period. He's still not in compliance because he skipped those years, but if you look at it in totality, for those 6 years, 2017 through 22, he's got enough according to his application. So that's all that's all my point to you was that, I guess if we're going to take the total for those 3 periods, 3 renewal periods, then he might be in compliance with that.
You just want proof of it.
Right, and I guess then we would then decide, okay, yeah, you weren't in compliance in your 2018 renewal period, but we're going to overlook that to look at the totality of the 6-year period. Maybe it just didn't articulate it very well before.
And he maybe due to what Wendy said, he doesn't have certificates going back that far. But if he doesn't, he can come in and then the board can assess his credibility as to whether he says he did.
He said he did.
or not.
He did.
Right, he says he did.
That would be a problem for me.
And we've talked about one issue being CPE in step 2. We're not saying that if CPE is okay, he's approved. The
got the motion, we've got the second, we've had discussion. Any further discussion? All right. All those in favor say aye.
Aye.
Opposed? All right, thank you. Board committees. Mr. Elmore, laws and rules. You want a break time? Okay. It is 10:02. What about 10:20? Come back. It was 18 minutes.